Simply because there might be some policy or raised eyebrow at a different interpretation of the law does not mean that the court should engage in Monday morning legislating and rewriting statutes that say something contrary to what the court believes it should say. And thus we must construe the statute using the customary principles of statutory construction. That includes the requirement that any language in a statute must not be construed in such a way that would render portions of it meaningless or superfluous. While there is obviously in Public Records Act cases also an explicit canon of construction that requires the liberal construction of the Public Records Act, that rule of construction in those cases cannot lead a court to ignore other mandatory canons of statutory construction or to otherwise rewrite what is already written in the statute.
On page 6, in the plain language of the statute, we have to look at the plain language when interpreting and discerning the legislature's intent, like this court stated before in the legislature's case. The plain language only permits agencies to produce records. It uses the word shall several times, and shall is construed by the Washington State Supreme Court, to confer a mandatory duty upon agencies. And if they wanted to confer a mandatory duty upon agencies, it would render that meaning optional if other agencies could produce the records and the agency didn't have to, which is this case. The record is clear that Lewis County did not respond to Mr. Portland's request. Lewis County did not provide any records, and if the Superior Court or any other non-agency could come in and provide these records, that would change that word, the meaning from the word shall, to an optional meaning, to meaning possibly, probably, or some other word. So we're changing the word shall from something else, and like this court said, the court doesn't have the authority to do that. The court needs to follow the legislature's words, the plain meaning of the statute, and the legislature's intent. And the legislature's intent through several parts of the statute and through Washington State Supreme Court case law is for the agencies in order to respond.
And so, but the writ of mandamus and associated relief is what you are to do to address these issues, and not to repeatedly get penalties and attorney's fees under the Public Records Act to, in effect, punish a county into the proper action to comply with the Public Records Act. And so I am dismissing this case with prejudice. I am aware of the disagreement and that I have agreed with that the Superior Court should not adopt the functions of the Law Library Board. But that issue in terms of requiring or relief or anything directly related to that is not before this court in this case. The question is whether or not documents were turned over and whether the adequate search has been done. And given the factual circumstances of this case, I am finding and concluding that that has been satisfied under the Public Records Act, and I am finding no violation of the Act as a result. Do the parties require any clarification regarding my ruling?
Yes, I do. This court just ruled that given the Superior Court has adopted the function of the Law Library Board, that there's not a violation. Is this court then saying that the Law Library Board is an agency, or that the Superior Court, when adopting the function of the Law Library Board, is an agency pursuant to 42.56.010 Section 1? And second of all, is this court overturning Nass versus Michaels, Koenig versus Federal Way, and the other cases that state that the judiciary is not an agency pursuant to the Public Records Act?
I'm going to allow my ruling to stand. So I'm not answering that question. I want to get well familiar with Judge Dixon's case. Judges talk to one another. I understand the issue in Judge Dixon's case, and I'm going to let you choose which of these orders I sign today.